Today we have the privilege to have a conversation with Mr. Sriram Panchu today, a pioneer in mediation in our country. Started his law practice in 1976 at Madras High Court and establishing the first court-annexed mediation centre. Uh, Thank you, sir, for taking time from your busy schedule. Sir, as working as being advocate for past 48 years, what was your early experience as an advocate in Madras High Court?
Well, the Madras High Court is very different from the Bombay High Court. Things are a little simpler over there. The pleadings are, not as elaborate. But it's also a court rich in scholarship. Judges actually do a lot of cases, and I found that court is pretty good at sorting out issues of common people quite quickly. There's a responsiveness there. So there is something to be said, for the court and the way it handles its work. But on the whole, it's a simpler bar. It's a simpler bar, which pans out in different ways. Simpler, more direct, but with a background of learning.
Sir, there is a constant debate between what's supreme, parliament or judiciary. What is your opinion about that?
I don't think it's a question of whether it's parliament or the judiciary. I think the constitution is supreme. And the constitution governs us. It is the ultimate holy book in our public life. And the constitution lays down, the powers and the duties and the limitations of everybody, including the government, the legislature, and the judiciary. So it is a question of the constitution being supreme.
So you initiated and established the first court-annexed mediation centre, and it's been more than 20 years. And could you just please say what has been the direction now? It's been more than 20 years.
Well, I think in these 20 years, mediation has moved quite well in the court sector, which means cases coming to court and courts referring it to mediation, and courts having their own mediation system where lawyers and some others come and mediate. That's come across quite well. There are a few thousand mediators, a few lakhs of cases are being mediated. Now the next big step is to take it more into private and professional mediation, where you don't have to go to court to get a mediator. You can access a mediator without having to do that. And to take it to different sectors, commercial sectors. Right now there's a lot of matrimonial cases and some commercial cases, but there are a lot more sectors to take it. Construction, finance, banking, real estate, corporate matters, other commercial matters, government contracts. So there are plenty of new sectors, places which are good, disputes good for mediation. So the big challenge now is to target those. And the big thing also is to make mediation professional, where people can take mediation as a career and can earn a reasonable income.
So do you believe that there should be a form of tribunal, just like other centers, or like how should it be separate as
No, people should be able to access a mediator of their choice. And they should be able to know these are the mediators, this is their background, this is their experience, and they should be able to choose their own mediators. That's the way it works best. If you choose your own doctor, you choose your person who needs to help you, choose your own mediator. That's the best way.
So I was going through various websites and found one interesting line. He brings the arena of legal disputes, the equivalent diagnosis and prescription in the medical world. Could you please elaborate on that statement?
Yeah. Where did I write that?
Your own website, Sriram Panchu.
Yeah. Well, it's a good point. I'll tell you what I mean. I mean that, you see, when you have a problem medically, you first get a diagnosis. And if you get a good diagnosis, that person will tell you, this is your problem. And for you, the best treatment is this. So he might say, go for surgery, or go for some other kind of treatment, or try homeopathy, or try Ayurveda, or try something else. There are multiple things possible, but this is the diagnosis and this is the best treatment. I think for disputes also, we should have that capacity of people being able to advise people, saying, well, if this is your problem, maybe you should go mediation, maybe you go arbitration, or you do litigation, or you do something else, or you do combination. One part you litigate, one part you mediate. Different things. But the capacity to diagnose. It's not like, everybody, it's like, suppose in the medical world you just went to a surgeon for everything. How would it be? So similarly, if you just go to a litigative lawyer for everything, what will he do? He will just say litigate. So the capacity to diagnose is very important for dispute resolution.
Thank you so much, sir.
And I want to say one thing. See, what I like about this institution, what I see is, the capacity and the willingness to do something a little more, a little different, to explore something. There's a freshness about it. And I would like to see that is, given its full scope.
Thank you, sir.
Right. You're welcome.